warahmatullah. Okay, can everybody hear me? You good? Okay, because I'm getting a message on my computer that my internet is a bit unstable. So if we have problems, then I may need to relocate. So just let me know if you're having any difficulty hearing me. So by way of background, this presentation actually started back in the 1990s when I was in Washington, D.C. A group of Muslim lawyers at Masjid Muhammad in Washington, D.C. Decided to get together to determine if we could accomplish the requirements of the Quran and the Hadith of Prophet Muhammad, may peace be upon him, in the context of Washington, D.C., Virginia, and Maryland law as it related to wills and inheritances. And what we discovered to our surprise and satisfaction was that we can, or we could in fact, accomplish everything that is set forth in the Quran in the context of those laws. And so in 1998, when I moved back to Minnesota, I did the same to determine whether the Quranic requirements could be accomplished within the context of Minnesota law, and determined that indeed they could. So with that background, we'll jump into the presentation, and I'm sure there'll be questions. If you could just jot them down on a piece of paper or pad, and at the end of the presentation, I'll try to answer those questions. I'm going to try to move through this fairly quickly so that we can get to the questions after this presentation. So the first question is, what is the authority for us as Muslims to have a will? And in Surah Baqarah, it gives us the authority. It says, and of course, this is the translation. It is prescribed for you when death approaches any of you, if he leaves wealth, that he makes a bequest to his parents and next of kin, according to reasonable manners. This is a duty upon al-mutakun, or the pious. So that's that begins the Quranic authority for us having a will. And then there's a hadith narrated by Sahih Bukhari that it is the duty of a Muslim who has anything to bequest not to let 2 nights pass without writing a will about it. And so that begins the quest or the responsibility for us as Muslims to have a will. And so let's actually jump into seeing what or who inherits under Islamic law. We have the wife, the husband, children, including grandchildren, great-grandchildren. We have the mother, grandmother, great-grandmother. And let me stop here. Not all of these relatives would necessarily inherit under one will, but these are all of the possible heirs that would inherit. So we have the mother, the father, aunts and uncles, sisters and brothers, and cousins. And again, some of these, such as sisters and brothers, aunts and uncles, would only inherit if some of the other more prior heirs are not available, such as children or mother and father. And we'll take a look at that as we move forward. So again, this is the Quranic authority for who gets what. I'll read this, and then in the next slide, I'll kind of show you how all of this breaks out, because just looking at it on this screen, it can be a little bit confusing. So it says, and for you is half of what your wives leave if they have no child. So in a husband and wife situation, if there are no children, the husband inherits half of what the wife leaves. But if there is a child, for you is 1/4 of what they leave. So again, as the husband, if there are children of the marriage, then the husband inherits 1/4. After any bequest made or debt. And as we'll see in the sample will that we have, the responsibility for paying debts takes priority over any bequests that might be left. For the wife is 1/4 of what you leave if there are no children. But if there is a child, then for the wife is 1/8 of what you leave after any bequests made or debt. And if a man or woman leaves neither ascendants, that means mother, father, grandparents, etc., nor descendants. So that means children, grandchildren, etc. But if there is a brother or a sister, then for each of one of them is 1/6. But if there are more than two, they share 1/3 after any bequest which was made or debt, so long as there's no detriment. This is ordinance from Allah, and Allah is knowing and forbearing, and this is in Surah 4, ayat 12. So just reading that, it's is a bit confusing. So let's look at the next screen and see who actually is included in these required distributions. And you'll see at the top, I call it fixed shares. These are shares that are prescribed in the Quran. And you see, I begin by saying that these must be Muslims. So if you have, or if we have, as I do, for example, I have non-Muslim family members, they would be covered in the bequests, which is up to 1/3 of what you leave. And we'll take a look at that a little bit later. But if we began looking at the fixed shares, the Quran says that for the parents, each of them is to get 1/6 if there are children. If there are no children, then 1/3 to the mother, and the remainder to the father. If there are siblings, that is brothers and sisters, the mother gets 1/6, and the remainder to the father. As we saw in the previous screen, if there's a spouse, the husband gets 1/2 if there are no children, and 1/4 if there are children. The wife gets 1/4 if there are no children, and 1/8 if there are children. In the case where there are children, the male child takes twice that of the female child, and children take the remaining shares after other fixed shares are determined. So we would go in order of importance. The parents are the first to take, followed by the husband and wife, and then if there's anything left after that, then the children take the remainder. And again, I appreciate and understand that all of this can be a bit confusing, and oftentimes it gets to be actually a mathematic calculation to determine who gets what. But that's a part of sitting down with with your lawyer to actually work through all of the requirements. But this is, this is just a general overview to kind of give you an idea. And then for each particular circumstance, we have to do an analysis and determine who gets what. In the case of siblings or brothers and sisters, they only take if one or more of the prior groups are missing. Residuary beneficiaries are those beneficiaries that are covered in the remainder of the estate after the fixed shares have been satisfied. And so they're entitled to inherit what remains of the 2/3, if anything, after the fixed shares have been determined. Now, legacies and bequests, a Muslim can leave up to 1/3 of their estate to a non-heir, that is someone who's not specifically prescribed in the Quran to inherit, but it cannot be an heir who has received a fixed share. And it may be made to non-Muslims. So oftentimes in the legacies and bequests, you may want to leave a bequest to, say, the masjid or some other nonprofit organization which that you've been involved with. That would come under these the 1/3 legacy and bequest. Or you may want to leave it to a non-Muslim relative or a child or someone of that nature who doesn't get a fixed share as prescribed in the Quran. Then we move to burial and funeral, in which there are some very specific requirements for Muslims that you usually want to set forth in your will, because it's been my experience, and this is dealing with Muslims and non-Muslims alike, that if there is no will setting forth who has a right to the body for example, in the burial, there can be a lot of chaos. I like to tell the story about a situation that arose some years ago now. This had to be probably back in the 1980s, as I recall. There was a Muslim brother who was married to a non-Muslim and had adult children, and had contracted a terminal illness and was about to pass. And he called together some Muslim brothers that he knew and told them that he wanted to have a janazah, Muslim burial and funeral. However, his wife didn't know he was Muslim, and his adult children didn't know he was Muslim. He had essentially hid his Muslim identity his entire marriage, but now on his deathbed, he wanted to be buried as Muslim. The problem was, A, his wife and children didn't know he was Muslim, and B, he didn't have a will. And so we actually went to court on behalf of the Islamic Cemetery Association to try to allow the Muslims to, and that included Brother Amin Abdul Qadir, to help grant this brother's wish. Unfortunately, because his wife and children didn't know he was Muslim and he didn't have a will, the court ruled against us. And so that's probably one of the most extreme examples that I can think of. But again, it just points out, especially a lot of us have non-Muslims. Some of us may be married to non-Muslims, and it's important to prescribe in your will who you want to has the right to the body. Normally it's a spouse, but if there is no spouse, or if the spouse is non-Muslim, you want to identify that in your will. In terms of the timing of the burial, normally it's within 48 hours. We do encounter situations in our community where we have immigrant Muslims who actually want to return the body to the original country. Well, that's really not in accordance with the Quran or the Sunnah of the Prophet, may peace be upon him. The requirement is that the body be buried right away. And in fact, in Minnesota, if the burial doesn't occur within 72 hours, the body has to be embalmed, and that's also not a requirement, or not something that's supposed to happen to the body. So Muslims don't follow or believe that the body should be embalmed. And you'll see the last item down there is the body to be buried in the place where the person died. In other words, it shouldn't be transported to wherever, because Allah knows best. No embalming or a autopsy unless local law dictates otherwise. In your will, you want to designate who performs the janazah, the proper preparation of the body. And in the case of a casket and grave, there's no casket unless it's required by local law. And in fact, most local laws do require some form of, and then the body is to be buried facing the Qibla. So those are some of the requirements of the janazah, and those are things that you want to set forth in your will to make clear. Other issues that come up, and I really need to update this presentation, but I'll go through it. So issues of guardianship. In other words, what do you do when there are minor children? Normally it's the other spouse that would have custody or guardianship of the children. But what if there is no other spouse? Or what if you have a situation where one spouse or another has not been involved with the children and active in their life? So you want to designate who the guardians of the children should be. And of course, you want to talk to that person or persons before you do that in your will. Sometimes we have adults who are in need of guardianship for either mental health or physical reasons that need guardianship, and who are heirs that you want to designate. And as I mentioned, you want to discuss this with these proposed guardians before you put them in your will. You certainly don't want to surprise them at the time of reading the will that they're the guardian of your children or your loved ones. Trust accounts. What if you pass leaving minor children before they reach an age of in which you believe they would be responsible enough to handle whatever assets that you leave for them. So you want to create a trust in your will, saying, for example, my child's share or other minor share should be held in trust by Brother McCrom, for example, until my child reaches the age of 21, 25, 30, or whatever age you designate. There's no legal requirement that you release assets to a child at a particular age when you're doing it in the will. And in fact, if you leave your estate to adults, so, you know, I'll take myself, for example, I have adult children, and if for reasons of mental competency or profligacy, which basically means that they're spendthrifts, that whatever asset money you leave to them is going to go right through their fingers, you may want to designate someone to act in their behalf. And who would that be? A trusted advisor, could be a financial advisor, family member, and you want to designate is the most important factor there when creating a trust account. You want to make sure that whoever you designate to handle the assets on behalf of either your children or someone has a mental incapacity, that you trust the person to handle those things. And so what does this actually look like in a will? So here's a sample will in which the first paragraph says that this person, wherever they live, let's say Minneapolis, Minnesota, being of sound mind and disposing memory. And in order to create a valid will, the person has to be of sound mind, and disposing memory basically means that they know what they're disposing of, and that they're not acting under any duress, menace, or fraud, or undue influence. In other words, somebody's not holding a gun to their head, or literally or figuratively to make them create a will. The preamble, and this is not a requirement, but most Muslims want to either put the Shahadatain in their will, or some other, they may want to put another Quranic ayat in their will that speaks to their own personal desires or interests. The first paragraph, you're basically saying that you're revoking any other wills, or a codicil is simply an amendment that to a will. That's just a legal term of art that we have here in Minnesota. So you're making clear that this is revoking anything else that might have been done in the past. Then the second paragraph usually indicate who we're married to, the date of marriage and the place of marriage, and then any reference to your spouse thereafter will be to that person. Third paragraph, third paragraph, you designate the number of children that you have and their date of birth, and specifically declare that you have no other children, either living or deceased. The word deceased is there because if you have deceased children, their children would take in their place under Minnesota law. Fourth, basically says that you have intentionally and with full knowledge omitted to provide for heirs who may be living at the time of your death, including any person who may become an heir by reason of marriage or otherwise, so that somebody comes and says, well, dad forgot about me, or let's say that there was a child outside of the marriage that's not included in the will. This is saying that if they're not in the will, you have intentionally omitted them. The fifth paragraph I kind of alluded to earlier. This says that all taxes and debts should be made, or should be paid, excuse me, before any distribution through your estate. 6, we get into the actual janaza portion of the will that says that no autopsy or embalming be done of the body unless required by law, and that the body be washed, wrapped, free of any ornaments, prayed for, and then buried without a casket unless the law so requires. And if a casket is required, that it be simplest, most modest, and least expensive form. And here you'll see there's a nomination of who you want to be the janaza representative and their address. And then usually if that person or institution is unavailable or unwilling to act, then you can nominate an alternative or appoint the local Muslim community, because as we talked about earlier, we don't know where we're going to be when we pass. And so the will designates as an alternative the local Muslim community where the passing occurred. The 7th is where we get into the 1/3 of the estate that you have the discretion to designate to anyone. They could be non-Muslims, or they could be Muslims for that matter, but not specifically covered for in the Quranic requirements. The 8th paragraph sets for the 2/3 of the estate that is distributed according to the requirements of the Quran that we looked at earlier. The 1/2 to the husband, or 1/4 to the wife, and the portion that goes to the children, etc. That's set forth here in the 8th paragraph. And again, it's going to vary from case to case, depending on what the facts and circumstances are of your particular situation. And this is a provision in the event that anything that you put in your will is inconsistent with the requirements and dictates of the Quran, you direct that an adjustment be made to conform with those requirements. The ninth paragraph deals with who you want to be the personal representative of your estate. Sometimes in some jurisdictions, we call that an administrator or administratrix. In Minnesota, that person is referred to as a personal representative. That means that they administer your will. They handle the probate through probate court and make sure that all of the requirements that you've set forth in the will are taken care of. Again, that should typically in a husband and wife situation, it's the surviving spouse of the two, but it could be others. The most important fact is that the person be someone that's trustworthy and that's going to carry out your request. The 10th provision, again, we discussed earlier situations that in which you may need a guardian for minor children or for an adult who is not competent to handle their own assets. 10th provision we talked about earlier, you may want to create a trust again for a minor child or an adult because of medical condition is not able to control the assets on their own. And this is just another provision of the trust that says in the event the person that you're leaving to passes away prior to the termination of the trust should distribute the principal to their children. So if it's an adult. And again, that's going to vary from situation to situation. And then the last part is just the witnessing, the signing and witnessing. Now in Minnesota, we have what's called a self-proved will. That means that if it's executed properly, the will proves itself as being authentic. And those requirements are that both the person making the will, which we call the testator, and two witnesses all sign in each other's presence. So you can't have one person sign one time and then another or two other people sign a different time. They all have to sign at the same time, and their signatures have to be notarized. And if all of those requirements take place, then you have what's called a self-prove will. In other words, you don't have to call witnesses at the time of probate to prove that this is the actual will of the testator. And what I always advise my clients and what I've done myself is to deposit the will with the probate court in the county in which you live. So for example, I live in Hennepin County, and so my will, my self-proved will, the original, has been filed with the probate court. Now, I advise that because one of the biggest issues that we have at the time of death is nobody knows where mom or dad or grandma or grandpa left anything. Okay, and so people are rummaging through the house or file cabinets to try to find the will or other important documents. And so it's the easiest, the simplest to just file the original with the probate court in the county in which you live, and then that way you avoid having to go through those kinds of issues. Before I get to questions, there are some other issues that I want to mention, and I kind of alluded to earlier. I need to update this presentation because there are some considerations in addition to a will that in modern day life we want to consider. One is having what's called a healthcare directive. And what that means is if something happens to you while you're still living, in which either physically or mentally you cannot make decisions or handle business on your own, you want to have a healthcare directive that indicates who you want to act on your behalf. So let's say, for example, you've been in a very severe car accident and you're in the intensive care unit, and a question comes up as to whether a particular medical procedure should be undertaken. Because of your condition, you don't have the ability to make that decision at that time. So A healthcare directive indicates who you have appointed to make that decision on your behalf. And of course, because of the nature of it, you want to make sure that that's clearly someone you trust and someone that's going to have your best interests, and hopefully someone that you've discussed these situations with before time, to let them know that, do you want to be given life support just to keep you alive, or just what? And so that's what a healthcare directive would do. The other issue that may come up is with life insurance policies or retirement accounts or pension accounts in which you've designated a beneficiary. So let's say you have a life insurance account in which you've designated your spouse, your husband and wife, or your children, or whomever. It could be anyone that you've designated as a beneficiary. That doesn't go through the probate process, so that wouldn't go in your will. So a question often arises for Muslims. So how do we deal with that situation? The Quran tells us that these fixed shares should go to certain heirs of ours, certain people, but all of our assets are either, let's say, in a joint savings account, or we have life insurance policies or retirement policies that designate beneficiaries. In all of those instances, your assets pass outside of the will. So then what do? Say you and your wife own a home, and we know under the Quran that the wife is supposed to be provided for 1 year of maintenance, and then depending on whether there are children or no children, she gets either a fourth or an eighth. How do we handle that? I don't have an answer for that, but that's something that we have to consider. Do we try to make sure that our joint accounts or our beneficiary designations are consistent with what the Quran is telling us to do if we put it in a will? So those are all things that you want to discuss with your lawyer, and we all know that that God knows best, and we try to make sure that we're doing what we believe and think is right. And then finally, there's a document that some of you may have heard of from time to time called a power of attorney. What a power of attorney is, again, it acts during the time that a person is alive to give them authority to make decisions on your behalf. And so let's say it's not a life or death situation. You're not, you don't need a medical procedure, which would be covered, say, under a healthcare directive, but you're in a situation where you really can't handle business on your own. And so you're going to appoint someone to act on your behalf. You can do that through a document called a power of attorney. And you can designate if you want to give them full authority to act in all instances, or just in specific instances having to do with, say, real estate transactions or banking transactions or things of that nature. So those are some additional considerations that I should update this and incorporate into this presentation, because they often come up as questions. So with that, I'll take any questions. I see your sister, Elena. Sister Elena, you're probably one of the few people that actually have a will that that I've done. And I want to mention, I've done this presentation so many times, but people have this fear of making a will because we're all fearful of dying, but we know that's going to be a reality, so we have to face it at some time. And I just like to congratulate Sister Elena, because I know she's one person who has actually made the decision to have a will. Alhamdulillah.
Brother Jeff, thank you so much for your presentation. If you could stop sharing your screen, and then we'll be able to see everyone who has a question. They can just kind of raise their hand. And when you do that, also what we want to do is make sure that you turn your camera on when you have a question, so we can see who's talking, inshallah. So if you, I will begin to acknowledge and unmute you as you do that, inshallah. Okay. All right. The first will be Abdul Kareem and Sister Elena.
Assalamu
Alaikum.
I'm sorry. I think I muted you on accident. Can you unmute yourself? Okay,
well,
there you go. There you go.
I actually had unmuted myself. But anyways, my main question is about the burial and facing the Qibla. Like, I have purchased a plot at a cemetery where the majority of my family are buried. And I don't know what their regulations are. What is the deal, and how serious is that, facing the Qibla? I guess that's my question.
Yeah, I'd probably have to defer to Makram or some other scholar who knows, would knows or be able to determine the answer to that. That's something that I wouldn't know.
Okay. Well, I appreciate that. Did you want to ask?
He has a question. Assalamu alaikum, Brother Jeff. Alhamdulillah, brother. Thank you for your presentation, brother. You're always in my prayers. I haven't seen you in a while, my brother. You're always in my prayers and thoughts, my brother. Thank you for your presentation. My question to you, brother, real quickly. The autopsy. Sometimes like the person is killed or dies something, and it's a legal matter in the court. I mean, the local authorities want autopsy. And so you say it's un-Islamic to have autopsy. I'm need no more clarity on autopsy as far as the death is concerned.
Yeah, basically what it says is that no autopsy or embalming unless required by law. So Islamically, we don't want to have an autopsy or have the body embalmed, but if the local law where we live requires that, then that would take precedence over our requests. And of course, one could always go to court to dispute that, but that leaves everything kind of up in the air or undecided. But to the extent that we can control what we can, then we designate or indicate that we don't want to have an autopsy, and we don't want to have the body embalmed.
Okay, thank you, brother.
We'll keep moving along for time's sake. Sister Arlene, unmute yourself. You have to unmute yourself.
Makram, while that's happening, someone has put in the chat box, where can they get the forms? Usually what I'll do is, if someone is interested, just email me and I will email them back copy of the sample will and have them fill in the portions that they're able to fill in. For example, who their spouse is, who their children are, those kinds of things, who they want to be their janaza representative, personal representative, things of that nature. And then we'll communicate back and forth, either by phone, Zoom, or email, until we get everything the way it should be. And typically that goes back and forth 2 or 3 or even 4 times until we lock down everything the way it should be. And so you can contact me directly via email to begin the process if that's something you desire. And then someone has asked what the cost of writing the will is. I do this as a service to the community, and so there's no charge. There's no charge for it.
Alhamdulillah. And Jeff, can you put your, I can't see if you have, can you put your email in the chat box? That would be great in case people wanted to respond for those documents, inshallah. All right, it looks like Arlene is now unmuted. Please go ahead with your question.
Assalamu alaikum. Can you hear me?
Wa alaikum assalam.
My question is regarding a revocable trust as opposed to having things go through probate. How does that actually work?
Okay, so let's say you own a home, a husband and wife own a home in what we call joint tenancy. At the time of passing, the home automatically goes to the survivor of the two. Now, what you have to file with real estate, usually in county recorder or somewhere like that, on your title, you would file a copy of the death certificate and right of survivorship. So that's done through the real estate process. Let's say you have a joint savings account, and a lot of people will do this. They'll include their children on the joint account, so that at the time of a passing,
Lost the volume.
The audio went out, Jeff. We can't hear what you're saying.
hello, testing, can you hear me?
We can hear you now. Yes.
Okay. I was mentioning in the case of a joint account, the property will usually go to the survivor. So if it's a husband and wife, it automatically go to the survivor of the two. But there's also a vehicle called a transfer on death, or a TOD. In that case, the person that the property gets transferred to is not a joint holder of the account. So let's say that mom doesn't want to have her daughter or son as a joint holder on the account. They can designate, however, that at the time of death, that account will automatically transfer to them. That's called a transfer on death, or TOD. Then for us that have retirement accounts, we can designate who those beneficiaries are, or a life insurance account, we designate who the beneficiaries are, and then that property goes directly to them at the time of death. You just have to typically provide a copy of the death certificate. The life insurance company will have the beneficiary's name and address and things of that nature, and you just have to prove that the holder of the the policy or the retirement account has passed away, and then it'll go directly to whoever the beneficiaries are that are designated. And so those are the typical instances that I can think of right off the top of my head: life insurance policies, retirement or pension accounts, or joint accounts, whether they're a joint savings account or a jointly held property, things of that nature.
Would you suggest the revocable trust as opposed to, well, not as opposed to, but if you have no joint tenancy with anyone, to have that designated so that, I guess I'm trying to see, do I want the trust versus having stuff go through probate? Is the trust,
Well,
does that?
Yeah, I think as a general matter, it's preferable to try to avoid probate, because A, it's an additional cost, and B, it takes longer. It's a lot of paperwork. I had to do a couple of probates, and man, it's like going to the dentist. I mean, just it's time consuming, and it's really a lot of paper shuffling, and it's just kind of aggravating process. And so if you can avoid it, but the thing is then now you have to determine, are you acting according to the requirements of the Quran, and how you best accomplish that. Because oftentimes, let's be real, sometimes we don't want to leave it to who the Quran says we're supposed to leave it to. And so we try to dance around that, but the Quran says that Allah knows best, right? And so we have to, we have to try to comply to as best as possible. And so, Sister Arlene, what I would suggest is, whether it's me or some other attorney, you discuss what it is you want to try to accomplish, and then come up with the best vehicle to make that happen.
Alhamdulillah. I saw Brother Shafiq. I think he put his hand down. I'm not sure if he got his question answered, but we'll move to Sister Blira.
Thank you. Assalamu alaikum. I have two questions, if that's okay.
Sure, go
Yeah,
ahead.
can you put on your video? Can you put on your video?
Yes, inshallah.
Okay, Assalamu alaikum.
Alaikum assalam. So I wanted to ask about the signing, where you want the witnesses and the person that have the will. Do they have to sign that in front of the notary, or they can do that in their home and then send that to you? How it works?
No, it has to be done in front of the notary.
Okay.
Yeah, when you're signing, each of you have to sign in the presence of the other and in the presence of the notary.
Okay. And the other question is about life insurance. Is that permitted in Islam?
Say it again.
Is that permitted in Islam, life insurance?
It's my understanding that term life insurance is permitted, as distinguished from, say, whole life insurance. That's at least what I've been told by by people who know more than I do about that issue. So the difference is term insurance typically doesn't accumulate savings. It's simply you're paying a set amount to provide a death benefit of a specific amount. But if that's a concern, I would discuss it with your imam, and oftentimes our imams may not know the answer to some of those questions, and so you keep going to higher authority until you get an answer is satisfactory to you.
Jazakallah khairan.
I think for the purposes of what we're doing here, both Sister Elena's question as far as being facing the Qibla and these questions here, I think there's some general answers, but we will take all of these under advisement to get more information about that. This is part of the, I think, collateral benefit of these sessions is to educate us to make the best decisions as possible, inshallah. So without taking up a whole long list of time, it's what we'll do the research and bring the necessary to really address those issues. So that we can have proper answers, inshallah ta'ala. What I wanted to do too, because since that was all the questions, what we wanted to have is, Brother Jeff, couple things. First of all, again, thank you very much for sharing this information. It's very much so. Many of us are in the boat where we need to put the wheels together. So I'm sure several else will be reaching out to you to help facilitate that process. The second thing is we're going to make this a recording available in our bulletin and likely on our website. With your permission, can we also have the copy of the slide deck to also do that for those persons who were unable to attend, but may want to go through the presentation as they're listening to the recording? Is that okay from you?
Well, I can provide the slide with the sample will, but the rest of it I would not want to provide.
Okay. All right. Whatever you can provide would be helpful. Inshallah, that would be helpful for those who couldn't attend today. And there is there is a couple of questions coming. It says, don't forget your email. Did you put your email in here? Or I don't see it.
Yeah, I did it, but it was a response to Abdul Karim's chat questions. So
maybe just put it to everyone, and then she can see it. And then it says, can we possibly have a wills clinic where we have the wills completed and notary, inshallah, Brother Jeff could be present?
Well, that's yeah, I understand what the desire is there, but typically there has to be some ongoing, some back and forth communications between the lawyer and the person that wants to do the will in order to get it to get it right. And it's I've never done it where, if it's been at one session, because there's just too many questions that have to be asked and answered in order to do it like that. But we have Zoom, and so I'm more than happy to meet with people one-on-one via Zoom. We can accomplish the same thing, and then get the will in the form it ought to be in for the person, and then arrange to. Typically, the person that's doing the will arrange for the two witnesses, and then, I can be present to notarize, or you can get a different notary. There's no particular magic in that regard.
Alhamdulillah.
But yeah, in terms of having it done at a wills clinic and having it done right there, that's not something that I would advise or would do myself, but I'm more than happy to meet with the person one-on-one. Either, in the current environment, it's difficult because of the COVID situation, but, meet one-on-one via Zoom, or if the person doesn't have Zoom access to talk on the phone or do email to answer questions and get the will finalized.
Alhamdulillah. Alhamdulillah. Thank you. And okay, we have another question from Sister Arlene, which will be our last. We're at 12:06 and we want to respect the time. So this will be our last question. Beyond that, we can email Brother Jeff directly And if you don't have it, you can reach out. We'll provide his email address so you can contact him. So go ahead with the last question.
My question was regarding the division of the person's who is deceased properties to their beneficiaries, or according to the dictates in the Quran. And I've tried to do that on my own, but I've never come up with 100% of what the value of the estate was. So there seems to be a percentage that's not calculated. Do you have any information about that?
Can you ask that again? I didn't quite get that.
Okay, like the mother gets so much, the father gets so much, the children, but it doesn't seem to add up to 100%. Is there some monies that's supposed to go someplace else, or how is that divided to get to say that you distributed the entire amount that you had?
Okay, so and is that situation in which you don't want to provide any other bequests to, say, a nonprofit or a masjid, or?
Okay, so if there is something left, is that how that would be distributed? So if I wanted to leave something to the masjid, and it was like whatever the percentage that's left, I could designate that for that voided space there.
Yeah, you can leave up to 1/3
Okay.
To someone other than a designated beneficiary, up to 1/3.
Okay. All right. I was just wondering because I never could get to 100%. So.
Yeah, like I said, oftentimes it's a mathematical calculation, and sometimes it doesn't work out, and so we just have to do the best we
Right.
can. Allah knows our intentions.
Absolutely. Thank you.
Yeah.
All right, alhamdulillah. This will conclude our, again, the first what we hope to be many or several financial literacy workshops for our community, inshallah. We do have others upcoming, one on tax planning and preparation. We have one on home ownership, even contemplating things like investments, cryptocurrency, all these things that are kind of in the environment right now help us to understand and navigate these things to see what is best for us as Muslims in our own individual situations. So more to come on this. And if there is other subject matter that we want to have discussed, please, you can email us directly, info@masjid-an-nur, and we will take that into consideration, inshallah ta'ala. So, alhamdulillah, thank you. Brother Jeff just posted his email address in the chat for those who need to have that to reach out to him directly. And again, Brother Jeff, thank you so much for this service to the community. May Allah bless you and reward you. This is tremendous information and something that we all must do soon, inshallah ta'ala. So thank you.
Yeah, you're welcome.
Alhamdulillah. All right, that will be it, inshallah. May Allah bless you all, inshallah, and we will see you at our next presentation. Assalamu alaikum wa rahmatullahi wa barakatuhu.
Wa alaikum assalam.
Wa alaikum assalam wa rahmatullahi wa barakatuh.
Yeah, this is